Hello, I'm Christina Jimenez with the Jimenez Law Firm, and today I'm going to give you a brief rundown, kind of a Cliff's Notes version of what you can expect when we are contemplating filing for divorce. Okay, so the first thing is the petitioner is going to file what we call an original petition for divorce, and essentially what that is it is a document where we say, hey judge, here's the affirmative relief that we are requesting from you. So if we have children, we have to make sure that we include the children in the original petition for divorce. And we have to say, okay, judge, we want what we call conservatorship. We want joint managing conservatorship. We want visitation. We want child support. We want certain rules that perhaps the children cannot be around this certain individual, or they cannot leave the country, things of that nature, okay? And then going to the property aspect or property component of this, because there's typically two different sides of the divorce proceeding if children are involved. So we have our suit affecting parent-child relationship, and then we have our property division. So when we're dealing with property, typically what you're going to see is a general request for what we call a just and right division, okay? Basically that just means, hey judge, we want you to divide this in a manner in which you deem is fair. Other times we will request what we call a disproportionate share of the marital estate. And basically what that is it's a request saying, hey judge, I don't want just potentially a 50-50 in this case. I want more because there was cruelty in the marriage. She treated me really badly, or she makes significantly more money than I do, and so I need to get a disproportionate share because I need to compensate for the fact that she has a greater earning capacity. There's all sorts of reasons why you can request a disproportionate share of the estate. So from there, typically what you're going to see is what we call a request for temporary orders. And so temporary orders are necessary most often in a divorce proceeding because in the state of Texas, it takes a minimum of 60 days to get a divorce. Now, if things are nasty and they're highly contentious and we have, lots of issues going on, most often it's going to take longer than the 60 days. And so what we have to do is we have to put some temporary orders in place to kind of put a band-aid over your particular situation and have the court render orders on how you guys are going to behave until such time as the divorce can be finalized. So again, two components. The first is going to be pertaining to the children, right? So who's going to have what we call the exclusive right to designate the primary residence of the child. Basically, that means where do the kids live, who's going to have visitation, who's paying child support, who's paying for health insurance, what are we going to do for uninsured medical expenses? Do we need to include passport provisions? Do we need to include rules that some people cannot be around the children, or that the children cannot travel outside of a certain geographic area? Those are the types of issues that we're going to be looking at when it comes to the kiddos on a temporary basis. Now, the second portion of that is going to be property, okay? So who's going to live in the house? Who's going to pay for the house? What car is everybody going to drive? Who's going to cover the insurance for those vehicles? Are we going to split credit card access? Are we going to have temporary spousal support? Okay. Those are typically the types of issues that the court's going to hear at a temporary orders hearing. And so that is typically a full-blown hearing, right? You're going to have to go in, you're going to have to testify, you're going to have to present your case to the court, and then at the end, the judge is going to make a render ruling. Oftentimes we do try to settle for temporary orders, but sometimes that's just not possible depending on your particular situation. So from there, we get an order in place. Once that order is signed by the judge, then you can be held in contempt of court, which means up to 6 months in jail and up to a $500 fine per violation if you do not follow those temporary orders. So from there, we have two options. Sometimes we can proceed directly to a final divorce hearing. Other times we have to go to mediation, okay? Most often, courts are going to require that the parties at least attempt mediation prior to going to a final hearing. And the reason why they do that is it's a way for them to do some sort of docket control so they don't have so many hearings scheduled. But also, I think it's an opportunity for clients to be empowered and to kind of decide what is best for their lives, as opposed to having, a complete stranger make a ruling after hearing, an hour to 2 hours worth of testimony. So I personally am a huge proponent of mediation. I have a lot of success with mediation. And I would say typically about 90 to 95% of our cases are settled at mediation. So at our firm, we do request or do require what we call a premediation meeting. Sometimes we have 2 of those. But basically what that is it is an opportunity for us to visit and for us to decide what it is that you really want out of your final divorce proceeding, okay? And so sometimes we have situations where people will say, listen, I would rather give him the house and, be able to move out of state with my children. Or listen, I'm going to give him, as much visitation as he wants, so long as he's going to, help me with the finances. It really puts you in a position to kind of decide, okay, this is what's most important to me, and this is what I'm willing to potentially give up in exchange for that, okay? Most mediations go anywhere from a half day to a full day. And at the end of that, you're going to sign what we call a mediated settlement agreement if you are obviously in agreement with the terms of that MSA, okay? Once you sign that MSA, it is a binding contract. And so I tell all of my clients that, number one, when we're preparing, you need to kind of have your mind, set on this is what I'm willing to do. But also, when you sign that, make sure that that is really something that you want to do, because once you sign it, there are no takebacks. It is a done deal. And so it's extremely important that you are prepared mentally to make those decisions. So after the MSA is signed, we take that MSA, we draft what we call a final decree of divorce, then we submit that to the court, the judge signs it, and typically you do have to have what we call a prove-up hearing, which is a short 5 to 15-minute hearing where we go in and we tell the judge verbally, especially if there's kids involved. You have to do it if there's kids involved, but we tell the judge verbally, hey judge, here's the terms of our MSA, can you please just sign this final decree of divorce, okay? Now, if for whatever reason you decide that mediation is not something that is going to work for you, and the court is going to allow you to not have to go through mediation, then you can proceed to a final divorce hearing. Or if you're not able to settle at mediation for whatever reason, then you have to go to a final divorce hearing. A final divorce hearing is, again, an opportunity for you to present your case and all of your evidence to the judge and make certain requests of him, right? So again, 2 parts, custody, property. Basically you're saying, hey judge, this is what I want to have, for the benefit and safety of my children. And judge, this is my final disposition of what I'm requesting that the court award to me as my sole and separate property. And so, the concern that I always have with the final divorce hearings, number one is the cost associated with it. Final divorce hearings are very, very expensive because most often they're very difficult, and it takes a lot of preparation to be able to do an exceptional job while you're in the courtroom. Second thing is kind of the emotional and psychological component associated with that process. I tell everyone that litigation is extremely difficult. It's difficult from a financial standpoint, from a psychological standpoint, from a spiritual standpoint. And so if ever you can avoid that process and avoid having to drag one another through the mud, then you're going to come out ahead. You're going to actually, win. So again, I'm a huge proponent of mediation for that reason. If you go to a final divorce hearing, you get to present all of your evidence to the court, admissible evidence, and then from there, the judge is going to make a final ruling as to what's going to happen with all of your property and what's going to happen with your children, okay? And so I hope that this video has kind of given you just a brief Cliff's Notes overview of what can happen in a divorce proceeding. Obviously, there are potential additional motions and things that could happen while we're going through this process. I tell all of my clients that this is not a 1 + 1 = 2 type situation. There is never just a perfect formula for this process because every case is different. Every client is different. The facts associated with all of your cases are completely different. And so you have to be very fluid and kind of patient and understanding while we're going through this process. But in general, if things go as smoothly as we would hope, what I've just outlined is kind of the overview of what's going to happen. Thank you guys for listening, and I hope you guys have a wonderful day.